Abuse and neglect of West Virginia's children is much more common than most of us realize. We'll talk about abuse and neglect right now on The LawWorks.
From West Virginia Public Broadcasting.
Closed captioning for The LawWorks is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The LawWorks is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia.
Reported child abuse and neglect occurs in West Virginia at the rate of nearly 2 children in 100, but that's the reported figure. My guest is West Virginia Judge Gary L. Johnson, Judge of the 28th Judicial Circuit, and that would be Nicholas County.
Yes.
Well, welcome, Judge Johnson.
Thank you, Dan. I'm happy you invited me, and I'm glad to be here.
You have a particular interest in child abuse and neglect. How did that get started?
Back in the early 80s, I began in private practice, but in 1985 I became a prosecuting attorney in Nicholas County. And I had a case which had been sent back from the Supreme Court, which involved physical abuse of a child in which her leg was broken. And the child, we went back to have the hearing before the judge, and there was no termination of parental rights back then. I don't think either of my predecessors on the bench in Nicholas County ever terminated the parental rights of anyone. And the result of that case was, even though the child's leg was intentionally broken, was don't do that again and don't let me see you back in here. So the child went right back and lived in the home, and I thought there had to be a better way, and that's when I started making this an issue that I cared about and have carried that all through the years.
And you've developed a particular expertise in that.
Well, in I think 1997, Justice Maynard appointed me as chairman of the Court Improvement Board. And what the Court Improvement Board is, it's a multidisciplinary board that tries to improve the procedure or processes of abuse and neglect. So I've really been involved in it since 1997 when that began.
Justice Maynard was Chief Justice Elliott Maynard of the West Virginia Supreme
Yes.
Court at the time.
Yes.
Our Supreme Court justices are allowed to pick up a cause or appoint committees or panels to particular issues.
And we've been very lucky in that regard because all of our Supreme Court justices have felt that this is an important area of the law. As you know, Justice Davis just last year did a truancy initiative, and prior to the last time she was Chief Justice, she made it a year of the child. Of course, Justice Workman has always been involved in children's issues, and Justice Benjamin, who will be Chief Justice next year, has made this a particular area of interest for him too. So we've been very lucky in the backing that we've had from our Supreme Court in this area of the law.
But you didn't really become aware of this until the mid-1980s.
That's correct. I grew up in a home with a mother and a father and a loving home, and when I was shocked when I became a lawyer and realized that these types of things occur to children. I had no idea and couldn't fathom that it would happen to children.
Was it invented in the 1980s? I mean, why didn't we see it?
Well, I think actually what it was, and it was the law and society at the time. And when we talk about abuse and neglect in the early 80s, it's been a constant shift, even since I've been involved in it, between the natural rights of parents to raise their children and the best interest of the children. And those have shifted back and forth. And at that time, the main issue in these types of cases were parents' constitutional rights to raise their children. And very few courts would interfere with that. It was just the way it was at that time.
Well, and literally, even till today, children are considered to be the property of their parents. Parents are entitled to the fruits of the labor of the children. And in fact, it's not been too many years where husbands own their wives too, and were entitled to the fruits of the labors of their wives. So we have progressed some of us, I guess, would like to say we're more enlightened than we used to be, but it's still a problem.
It is still a problem, and but the U.S. Supreme Court has said that this is one of the exceptions to the right of parents to parent their children, is when they have proved unfit or have done something to the child in which they forfeit that right. So that decision, I think, was made in the early 80s, and that's where all of this has developed since then.
Well, certainly intentionally breaking a child's leg or something of that ilk would be child abuse. But what is abuse and neglect? How's it defined? What does it mean?
Well, abuse is pretty much what you think it is. It's physically abusing or emotionally abusing, and the when you have cases of physical abuse and sexual abuse, those are not difficult cases. The difficult cases come when you have parents who sometimes just don't have the capability to care for children, and those are very heartbreaking cases because those parents really love their children, but they just don't have the capabilities to raise them. And you try to give them all the help that you can, and you try to give them services so that you can keep that family together, but it doesn't always work out. Now, in the cases that we have now, I would say 90% of those cases are substance abuse issues, and it's prescription drugs in southern West Virginia, and methamphetamine. Those are the problems that we have in southern West Virginia, and I would say 90% of the abuse and neglect cases in the area that I'm from result from substance abuse.
Substance abuse by whom?
By the parents, not able to care for their children because they're out they're either high on opiates or they are out seeking drugs to continue their addiction.
It seems like the quest for drugs and alcohol is the source of most of the crime that we see in courts in West Virginia and maybe nationally.
And absolutely, and I'm speaking for myself. I'm not speaking for the Supreme Court or anything, but I think that all children have a right to have a safe and stable and suitable home, and they have the right to an adequate amount of food. They have a right, and I don't know quite how to phrase this, but a right to lay their head down in a place where they can get a good night's sleep. I mean, either because of they don't have an adequate place, or because there are people running in and out, buying and selling drugs or having parties that most kids don't get a good night's sleep, and they end up going to school, then they end up falling behind in school, they end up dropping out of school, and that's the life they have, and they're in they're on the train to prison, and I honestly think that that the children have a absolute right to have a safe and stable and suitable and permanent home. And that's the purpose of the abuse and neglect process.
A right to be secure.
Yes.
We're talking about abuse and neglect. My guest is West Virginia Judge Gary L. Johnson, Judge of the 28th Judicial Circuit. I'm Dan Ringer, and this is The Law Works. If you know or suspect of a case of abuse or neglect, you can make and should make a report of that to the Abuse and Neglect Hotline. In West Virginia, that number is 1-800-352-6513. 800-352-6513, and you can make that report 7 days a week, 24 hours a day, even if it's just suspected child abuse. Now, if I suspect child abuse, my neighbor or my cousin or somebody I suspect they're abusing their child, and I make a report, am I going to get sued for doing that?
All of the referrals to the Department of Health and Human Resources and the hotline are completely anonymous, and even a court cannot force they have an absolute privilege not to reveal that information even in court.
Some people are required to make reports like that.
Well, I was going to talk about mandatory reporting a little bit. As you know, next door, the president of Penn State, the athletic director of Penn State, and all of those high officials there, under West Virginia law, they would have had a duty to report. I'm not sure about Pennsylvania law. They're all indicted, and I don't know where that's going to end up. But if you're a teacher, if you're a social worker, if you're a judge, if you're a family court judge, if you're a lawyer, you have the absolute right to report, or the absolute duty to report suspected child abuse. You're a mandatory reporter, and you must do that.
Actually, I did that one time. I'd been a lawyer for about 20 minutes years and years ago, and a gentleman came to my office to talk about possibly getting a divorce, and I said, why is it that you want a divorce? And he started describing the things that his wife was doing to the children. And I said to him, I think we need to report this. In those days, mandatory reporting was not what it is now. But I said, I think we need to report this to Health and Human Services. And he said, I'm afraid to do that. I said, I'll do that. And I did, and Health and Human Services picked up the kids at school, went through whatever the process was then. The father got them, the mother was removed from the house, and the case then went on and was resolved favorably to the children. And that's really your guidepost.
And that's one of our jobs as judges. And we're to assure that the process is timely, and we're to assure that the process puts the child in a permanent and safe home environment. Whether that be reunification with the family is that's the gold standard. That's what we all try for. But at the end of these cases, sometimes that's not possible. So then we adopt a permanency plan, and it's our responsibility and duty as judicial officers to move that case along so that's done as quickly as possible. Now, I was going to talk a little bit about our circuit judges in the state are very busy. And I was looking at the statistics in preparing, and in 1994 we had 647 abuse and neglect filings, and in 2011 we had 3,135. Now what that means is each of those cases requires at least 3 hearings. It requires a preliminary hearing, it requires an adjudicatory hearing, and it requires a disposition hearing. And then after that, it requires a 90-day review of each of those cases. So if you can imagine that you're reviewing, in my case, let's say we're on 85 cases this year, and I'm reviewing each of those every 90 days, that's a pretty full docket, and every circuit judge in the state is working very hard in order to assure permanency of these children as quickly as possible.
Well, you just go through the motions. You have the hearing, and it's over, and you say, don't do that anymore.
Well, that's the way it used to be, I agree, but we have really made some efforts. And one of the reasons, one of the things that we've done in the Court Improvement Board to try to increase that is every judge now can go online and look at his statistics in each abuse and neglect case. And I went to a national conference one time, and there was a lady judge giving us a seminar, and she said, if you truly want to improve something, measure it. She said, if you measure it, it will improve. So the Bureau of Children and Families of the Administration of Children and Families of the Department of Health and Human Resources in the national department, they funded for us a database. And that's what this database does. And I'm happy to say, as I look at these figures, every figure has gone down. The time to adjudication average days, the time to termination of parental rights, the time to permanent placement, all of those have gone down. This shows from 2007 to 2012. And that's not only the hard work of the judges, it's the hard work of the guardian ad litems, it's the hard work of the lawyers doing scheduling who represent parents, it's the hard work of the Department of Health and Human Resources, and it's a collaboration to try to get these hearings done as quickly as we can get them done.
Let's talk about the process. You talked about adjudicatory hearings, dispositional hearings, review hearings. I call Health and Human Services, the Health and Human Services hotline, again, 1-800-352-6513. 800-352-6513, 7 days a week, 24 hours a day. If you even suspect child abuse, and certainly if you know of it, 7 days a week, 24 hours a day. Make the call. It's anonymous. You won't get in trouble for doing it as long as you're acting in good faith. So the call is made, Health and Human Resources takes it, and they process it, fill out forms, take information, and it comes into the court system. What happens?
I was going to say they have a procedure whereby they have to investigate they have a certain amount of time where they have to investigate every complaint. So then they go to the prosecutor, which is another collaborative partner. And the prosecutor represents the Department of Health and Human Resources, and the decision is made there whether it amounts to the rises to the level of an abuse and neglect case, and they decide to file a petition. When that petition is filed, we have to have a preliminary hearing within 10 days to determine if the children should remain outside the home pending the final hearing.
The children are taken into custody of DHH?
If there's imminent danger. That's the standard. If the court finds that they're imminent danger and the juvenile referees do that, those are the magistrates in most counties, and they have to clear that with the circuit judge before they can sign the order. Then once those children are taken, we have 10 days to have a preliminary hearing to make sure that it's in the best interest of the children to remain outside the home pending the adjudicatory or final hearing, and we're required to have that within 30 days. We're not meeting that standard statewide yet, but we're very close to meeting that 30-day timeline. And adjudicatory hearing is like a trial. I mean, you go into the to the hearing, and the state has to prove by clear and convincing evidence that the matters in the petition are true, and the judge makes a finding after the presentation of evidence, and of course the parents get to present any evidence to the contrary. And it's those are very lengthy and take a lot of time, and sometimes you can get those done in a day, and sometimes you can't. So they're very difficult and very time consuming.
The term adjudicatory means to adjudicate, and as you say, that's the trial of the matter. You look at the facts, you look at the law, you apply the law. Now, do you get a jury at one of these hearings?
You're not entitled to a jury. It's all judge-driven, and the judge makes a decision in each of the cases.
Okay. You have the adjudicatory hearing, and you find that there was some form of abuse or neglect. What happens next?
Then, in most cases, in the drug cases that we talked about, you usually grant the parents an improvement period to allow them to go to rehab, to try to provide them services so they can get a safe and suitable home. A lot of times we will say, to the department, help these people find an apartment and pay their deposit and 1 month's rent so they can establish. And a lot of times they're domestic violence situations where that's very helpful. And we try to provide any counseling, any parenting services, life skills services, anything that you might need in order to be a good parent. That's the time we try to do that. And every drug case that I know of, the parents are granted an improvement period to determine if they can get rid of their addiction and properly parent the child.
You mentioned domestic violence cases. It is horribly, tragically true, and it usually happens with women, with the mother of the children. That's just the way it happens. I'm not trying to be sexist about it. It's just the way it happens. The mother watches the children be abused or is aware of the neglect and feels powerless to do anything about it, oftentimes because she believes that if she complains or if she leaves, she's not going to have support for herself or for her children, or she's going to be further abused by her husband. And those ladies can be good, competent mothers if they can get out of that situation.
And about 4 or 5 years ago, the legislature adopted co-petitioning, which allows an abused or neglected parent to join the state in co-petitioning against the person who's the abuser. Now, what happens in those cases, if they do not join the state or they're found to not protect their children, then they can become respondents on the other side. But the law does allow them at this point, because of the domestic violence, to become co-petitioners with the state so that they can participate in the whole process, but not as a respondent, but as a party.
We're talking about abuse and neglect. My guest is West Virginia Judge Gary L. Johnson, Judge of the 28th Judicial Circuit. That's Nicholas County. I'm Dan Ringer, and this is The Law Works. If you are aware of abuse and neglect, or have a good faith belief and suspect abuse and neglect, you can call the West Virginia Abuse and Neglect Hotline at 1-800-352-6513. 800-352-6513, and you can make that call 7 days a week, 24 hours a day. And it can be a single event of abuse. It doesn't have to be an ongoing pattern. As long as you make that call in good faith, it will be anonymous. You will not be held responsible by any court anywhere for making that call. So make the call. Don't let abuse or neglect go on. And it doesn't matter whether it's a relative, a next-door neighbor, or a friend. Make the call, 1-800-352-6513. I cannot emphasize that too much.
And I was at the law school this morning at a seminar on child protection. That was the choice of their law review to do a seminar on that. And a lady from Kids Count, which is a West Virginia agency that keeps track of statistics, said all we're trying to do is make West Virginia a good place for kids to grow up. And that was the best definition of this whole process that I've heard in a long time.
In the abstract, it's a beautiful place. The people are kind, but abuse and neglect can occur in some of the darndest families.
It can, and the effects are profound on some of these children. They're more likely, if they're in the abuse and neglect process, to end up in the juvenile delinquency process later. And we have lots of children in foster care. As a matter of fact, our majority of children in foster care now are between 15 and 18. And because children, young children are easier to adopt. I mean, that's just a fact. And those children, probably under 6 or 7, they're adopted very quickly. They're put up for adoption and they're adopted. And I think that we have at this point in time 1,000 children waiting adoption in West Virginia, and most of those, a majority of those, are between 15 and 17 years of age.
We were talking about the improvement period. How long does this period go on?
Well, we are required by law to allow, we can't go beyond 15 months. So there's, under West Virginia law, you can have a adjudicatory improvement period, which could last 6 months, which is capable of extension to 9 months. And then you can have a disposition hearing and have an additional 9-month. So we're talking about 18 months altogether allowable under West Virginia law. Although the West Virginia legislature last year, to be in accordance with federal law, says that we're to do it within 15 months now. So that's our outside limit.
So it tightens the time.
One combination of adjudicatory and dispositional improvement periods.
How often do you bring the case back into your courtroom?
Every 90 days. Look at every one of them every 90 days.
What do you expect to see?
We expect to see some improvement by the parents. We expect to see the department. It's not only for the parents, it's for the court to make sure that the department workers are doing what they're supposed to do by providing the services necessary in order to try to reunify the family. So it's a check on both the parents and the department.
And before somebody says, oh, the Department of Welfare, the Department of Health and Human Services, doesn't do anything, or they just sit on, I think the most stressful role for a social worker is to be a Child Protective Services social worker.
No question about it. It's dangerous. It's just as dangerous as being a policeman. I mean, you're going into people's houses and taking their most precious thing away from them, their children. And it's very dangerous, and it's very frustrating work. I mean, it can be very, very rewarding in the end, but it's very frustrating work and very dangerous work. We pay our CPS workers very low, so they're both underpaid and overworked. And a lot of times, unless you're really committed to the issue, as soon as a job comes up in another area of DHHR, which pays a little more and is less stressful, they go on. Right now in my county, I think every CPS worker has been there less than 2 years.
They burn out.
Yes.
It's very difficult. I have known Child Protective Service workers, social workers, over the years. I've been a lawyer now for 34 years plus, and they are very sincere people. They work very hard. They misjudge things sometimes. As you say, some of the cases can be rewarding, but for every case that is rewarding, they've got 10 more or more that they have to shepherd that are not providing any rewards at that time.
And a lot of times you just want to say to the parents, just quit, don't do that. But I know it's difficult to do. It's just like, when you become addicted to opiates, they say that it's one of the worst addictions that you can have. And you know what problems that people have trying to quit smoking, for example. You know, it's very difficult to do that. So you can
Or
imagine
overeating.
or overeating. So you can imagine an opiate addiction. And so it's very, very difficult for children to do that, and for parents to do that. And and we have a very limited amount of time to do it under both federal and state law now. So, and you have to tell them up front, this is going to be very hard work. This is something you're going to have to work at, and you're going to have to remain in contact with your social worker, and you're going to have to jump through these hoops. That's just the way it is.
How much time does this whole process consume in our court system?
Well, I was talking to 3 other judges last night. We were at a social work conference in Beckley, and we came to the conclusion that it's probably taking about 40% of our time now. Even by case statistics, it's not that much, and time-wise it is. By the time you have all the review hearings and the 3 or 4 hearings that are required in order to conclude the case, it's taken a significant amount of time.
During these improvement periods, the children are not necessarily in the home with the parents.
In most cases, they're not in the home with the parents. I would say 60 or 70% of them, because the parents, most of the time in these types of cases, are in an inpatient rehab. And, and there's no one to take care of them. We try to place them with parents or relatives, grandparents, relatives, aunts, uncles. And that's one of the requirements under the new Fostering Connections Act that the Congress just passed. And so we have to check with relatives first before we place the children in foster care. Foster care many times can be as punishing as being back in your regular home, depending upon the type of foster parent that you have. We have very good foster parents, just like anything else, but we have some that aren't so good.
Well, Judge Gary Johnson, thank you, Judge Johnson, for coming and being with us this afternoon.
Well, thank you, Dan, for inviting me. Appreciate it.
If you suspect child abuse or neglect, just a good faith suspicion, or know of it, Call the Abuse and Neglect Hotline at 1-800-352-6513. That's 800-352-6513, and you can make that call 7 days a week, 24 hours a day. Again, Judge Johnson, thank you.
Thank you, Dan.
Thank you also for being with us. On behalf of the Law Works, I'm Dan Ringer. Good evening. If you would like to suggest a topic for a future The Law Works show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us an email to thelawworks@comcast.net or visit us on Facebook. On the Law Works website at thelawworks.org, you'll find a listing of recent The Law Works programs, additional information about this show's topic, and video of this and recent shows. You can also find the Law Works programs on YouTube and iTunes. The Law Works is produced in cooperation with the Office of the West Virginia Attorney General, the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The Law Works is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia. Additional support for the Law Works is provided by the West Virginia Supreme Court of Appeals.
From West Virginia Public Broadcasting.